Welcome to another episode of Courtroom Chronicles, Persuasion and Persuaders. I'm Mia, your co-host and legal enthusiast, and with me today is my longtime colleague, George. Today, we're diving into the intricate world of courtroom rhetoric and persuasion. We'll explore not only the importance of tone and delivery, but also how the right choice of words can change the course of a case.
Absolutely, Mia. There is a rhythmic art to a courtroom presentation. Every word is calculated, and every pause is deliberate. You might even say that a seasoned attorney's speech is akin to a finely tuned instrument designed to move hearts and minds. Today, as we discuss persuasive courtroom speech, we'll be focusing on key legal terms that you should get to know, including phrases that you'll soon encounter in our gap-filling exercise.
That's right, George. Before we get into the meat of our conversation, let's review why these legal phrases matter. Consider the term "hear good cause." It's a request for the court's leniency based on compelling reasons. Then there's settlement, which, in legal parlance, denotes the resolution of disputes without a trial. These words aren't just jargon, they are the backbone of many legal strategies.
And don't forget the simple yet powerful word offer. In many negotiations, a well-timed offer can change the direction of discussions. Speaking of which, sometimes the goal is simply to settle, meaning to resolve a dispute amicably, instead of going head-to-head in a contentious trial. The phrase "to proceed" signifies the continuation of legal action, while "trial commence" signals the start of judicial proceedings. Then there's the classic objection, a call to halt proceedings when something improper is happening in the courtroom. Finally, when an attorney says "get to the point," it is a reminder to be concise and persuasive.
That's our word bank for today's session. We want you to become comfortable with these terms and see them in context. Now, let's move into our discussion by exploring how tone and choice of language can affect a trial's outcome. I'll begin by setting the scene. Imagine a busy courtroom where tension is palpable and every remark could shift the momentum of the proceedings.
Picture this: an attorney pacing slowly in front of the jury with a calm yet assertive tone. They might say, "Your Honor, we respectfully request that you underscore in favor of our client because there is clear to grant relief." Here, the pace of delivery and the certainty in their voice create an ambiance of authority. This technique, often drilled during trial preparation, reinforces the attorney's credibility.
Exactly. In such moments, every word is measured. Let's discuss a scenario. Imagine you're in a civil dispute where both parties are poised to exchange heated arguments. The defense attorney might start with, "Ladies and gentlemen, I present an that is not merely a number on a page, but a genuine attempt to underscore this matter before it escalates further." Notice how the words chosen not only convey intent, but also offer a resolution without igniting further conflict.
I love that example. It shows that sometimes the best strategy is to propose a underscore rather than force the issue into prolonged litigation. By doing this, the attorney hints at the possibility to underscore the conflict, a move that is often welcomed by both sides, especially when the stakes are high and public attention is under intense scrutiny.
Furthermore, consider the moment when proceedings are about to unfold. An attorney may state, "If the court agrees with the presented evidence, we respectfully ask permission for the underscore of the underscore. This isn't just procedural, it's a moment where the attorney communicates clarity and command. It's all part of the persuasive art of invoking orderly process.
And when things don't go as planned, when an opposing counsel attempts to steer the narrative off course, the sharp interjection of an underscore becomes a turning point, a signal to all parties to recalibrate. It's a word that, while simple, carries the weight of justice and process. In these situations, the phrase "please underscore" can be a gentle yet firm reminder to avoid excessive elaboration and focus on the facts.
I often think that the balance between persuasion and brevity is what defines an exceptional legal advocate. Whether it's an emphatic plea for underscore, underscore, underscore based on irrefutable evidence, or calm invitation to underscore, underscore, underscore carefully considered negotiations, these terms encapsulate strategies that keep the proceedings both respectful and focused.
Let's now venture into a simulated mini-trial scenario. In our exercise today, I'll play an opposing counsel, and you'll portray the advocate representing the plaintiff. We'll stage a brief courtroom dialogue. Are you ready, Mia?
Absolutely, George. Your Honor, I urge the court to consider that there exists undeniable underscore, 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 justifying an immediate recalibration of this case. Our client's plight is evident, and we cannot afford to drag these proceedings indefinitely.
Counselor, while your argument carries emotion, we challenge the premises lacking the requisite veracity. I contend that this case should not be subjected to a premature underscore, 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 underscore. We need a thorough review before any decisive action is taken.
Your point is noted, but the facts speak for themselves. Without delay, we propose a underscore, underscore, underscore. That reflects the seriousness of the matter, inviting both parties to an earnest negotiation to underscore, underscore, underscore the conflict. The evidence will, we trust, prompt the court to allow us underscore, underscore, underscore in a timely manner.
I must interject, Counselor, with an underscore, underscore, underscore. Let's be clear. Only when the arguments are structured and concise should we move forward. Ambiguity here risks misunderstanding our client's true intent. In fairness, it's high time that we underscore, 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 and address the key issues directly.
Very well, I appreciate the reminder. Let's underscore, 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 underscore by focusing on what truly matters, justice for our client. Our strategy is not to complicate proceedings, but to articulate our case with precision, ensuring that each step, from underscore, underscore, underscore to negotiation, is built on a foundation of clarity and fairness.
I see your point. Let's imagine the courtroom in full session. The judge, an embodiment of impartial justice, asks for succinct arguments. You rise and state, "Your Honor, I submit that the available evidence clearly supports our claim. Should the court find underscore, underscore, underscore convincing, we would be prepared to propose an immediate underscore, underscore, underscore to resolve the dispute amicably."
Not only that, but should any party attempt to derail this process with extraneous points, the response should always be, "Please, underscore, underscore, underscore." This simple yet effective interjection maintains order and ensures the trial's momentum remains undisturbed. This is what separates a seasoned advocate from a novice. Knowing when and how to invoke essential courtroom procedures.
In real-life courtrooms, these moments are pivotal. I recall a landmark case where an attorney's deliberate command to underscore, 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 underscore resonated through the courtroom. It wasn't just about halting irrelevant details. It was about commanding respect for time and the judicial process. The judge's subsequent nod validated that sharp focus, which led to a swift and just resolution.
This entire discussion reinforces that language in the courtroom is never mere rhetoric. It's the tool by which justice is communicated. When an attorney articulates a plea to underscore, 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 they are in effect inviting the court to lean on compassion under the framework of legal discipline. Similarly, a willingness to underscore, underscore, underscore a case reflects maturity in handling disputes.
Moreover, the sequence of these phrases forms a rhythm, almost like a carefully choreographed dance. Imagine an attorney beginning by asking the court to, then segueing into proposing an underscore, 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 that can quickly underscore, 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 underscore. At each juncture, the precise moment chosen for an interjection such as da can shift the energy and direction of the trial.
At times, the conversation might even pivot on one simple, direct command. You might hear, in a high-stakes moment, "Your Honor, please allow us underscore, underscore, underscore." This moment, brief as it is, encapsulates a plea that is both tactical and emotive. It signals that the time for deliberation is over, and the time for action is now.
Let me recall another instance. In a widely covered dispute, the attorney representing the plaintiff insisted, "Before we proceed any further, let's underscore, 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 underscore." That moment, punctuated by measured silence and a focused gaze, underscored that the essence of justice lay not in verbosity, but in clarity and action. It's this notion that pushes the dialogue directly to the heart of the matter.
Indeed, George, these aren't just memorized phrases, they are integral parts of a persuasive strategy. They work together to steer the dialogue from preparation to negotiation to resolution. In one memorable session, after establishing a foundation with detailed evidence, the attorney calmly proclaimed, "It is time for the underscore, 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 underscore." What a succinct way to signal that the rigmarole of preamble must give way to decisive action.
And then the opposing counsel, not to be outdone, would typically retort with a measured pause followed by, "I must respectfully raise an underscore, underscore, underscore." This back and forth is what makes courtroom debates so riveting. It's a delicate balance of respect, strategy, and advocacy, highlighting the pressure cooker environment in which these decisions are made.
This dynamic interplay between the attorneys encapsulates the spirit of litigation, a strategic tug of war where every term, every pause is weighted with significance. The essence of persuasive advocacy is ensuring that the intended message is delivered clearly while leaving no room for misinterpretation. The terminology we discussed today is not arbitrary. It is a lexicon honed over generations of legal practice.
I'm reminded of the notable performance during a high-profile civil case where the defense attorney's methodical use of these terms shifted the jury's sentiment dramatically. The courtroom was abuzz as each timed interjection, especially when the attorney emphatically declared, "Let us underscore, 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 and not waste time with irrelevant details," reinforced the gravity of the proceedings and highlighted the importance of efficiency in legal argumentation.
Let's also consider the psychological aspect. A well-delivered phrase such as, "I urge the court to underscore, 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 underscore," considering the compelling evidence presented, taps directly into the emotional and rational faculties of the decision makers. It demonstrates not only legal acumen, but also a deep understanding of human psychology. When listeners and even jurors sense that the advocate is confident and focused, it builds a persuasive narrative that transcends the literal meaning of the words.
That's an excellent point. These terms, when executed with the appropriate tone and cadence, resonate on a level beyond mere legal protocol. They embody the spirit of justice, urging all present to look at the facts with clarity. It's a reminder that law and rhetoric are intrinsically linked, a fact that every aspiring legal professional must appreciate.
On that note, let's reflect on our conversation. Today, we've illustrated how the judicious use of legal terms like hear good cause, settlement, offer, settle, to proceed, trial commence, objection, and get to the point not only shape courtroom proceedings, but also enhance the persuasive power of advocacy. Our discussion shows that whether you're negotiating behind closed doors or addressing a full courtroom, precision in language is indispensable.
Absolutely, Mia. And it's clear that mastering these terms and the contexts in which they are best utilized is vital for anyone looking to make an impact in legal proceedings. Whether you're drafting briefs, negotiating settlements, or arguing a case in court, the precision of language can make the difference between success and failure. Our discussion today is a call to recognize that every term, every inflection, and every pause is a tool in the larger arsenal of persuasive communication.
I hope our listeners have found this deep dive into courtroom linguistics enlightening. As you review the transcript and prepare for the gap-filling exercise, think about the power these terms carry. They are not mere words, but instruments of persuasion, capable of steering outcomes and reinforcing justice in a courtroom setting.
Before we conclude, let's recap. Understand each term, practice using them in context, and when the moment calls for it, use a firm underscore, underscore, underscore to ensure that your arguments remain sharp and focused. Remember, as advocates, getting to the point isn't just a stylistic choice, it's a strategic imperative.
Thank you for joining us on this journey into the art of legal persuasion. We encourage you to revisit your notes, practice these terms, and appreciate the subtle yet powerful dynamics of courtroom dialogue. Until next time, keep refining your advocacy skills and always strive for clarity and precision in your language.
This has been Courtroom Chronicles, Persuasion and Persuaders. I'm George.
And I'm Mia. Stay sharp and may your arguments be as compelling as they are just. Thank you for listening.